Welcome back to the Law&Crime Network. My name is Bob Bianchi. I'll be with you till 3 o'clock today. We're going to have a really special, important guest that's going to come up and talk to us a little about Scott Nelson's case. But in the meantime, while we're getting that set up, the prosecutor gave an opening statement in the penalty phase of this case. Now, all reasonable people looking at this, and I could tell from our chatters and people talking in the back room here at the Law&Crime Network, and even myself could say, what could this guy possibly do, or the lawyers in particularly, to get this guy out of the death penalty? Because it's such a bad case factually, as well as the fact he's such an unsympathetic, remorseless person, and his testimony was just really out of control in terms of bad for him. Zip ties, don't leave home without them. I mean, gosh, almost thumbing his nose. But don't forget, one juror got thrown off because they said during the penalty phase that they didn't think that this was a penalty case after they had listened to the testimony in the guilt phase. So you could always find that one juror. Is there another one lurking within the 12 that are deliberating on this case? We just don't know. And the prosecution is, the defense is trying their best to save his life. But the prosecutor obviously wants to make sure that they get a penalty conviction, so they're going hard at it as well. Let's take a look at their opening statement, and I'll be back with our special guest on the other end. Penalty phase of this case, Judge Ashley Willcott, our very own here at the Law&Crime Network. Prosecution did a really good job detailing the torture aspect of it and getting into the idea that it's not all three of those areas, but any one of those areas. And boy, I mean, when he went through those facts about her being duct taped and stabbed and the brutality of it, I mean, I don't think there's anybody who's going to say that's not going to be an aggravating factor found. What do you think?
Oh, I agree with you. And so, as you well know, Bob, he has to prove at least one aggravating factor. I think there's 16 in the code, if I'm right on that, in the state of Florida. I think he could prove up to 5 of them. When I read the statute, I have it printed out, and I really believe that he's not going to have any issue at all factually supporting aggravated circumstances. I think that's going to be a check.
Yeah, so, I mean, what do you think is the defense's best shot here? Is it, I know they're trying to bring out a bad childhood and being in jail and the stresses of that. Something that was compelling to me was that the brother also testified in this case and brought out a lot of information for the defense. I haven't had an opportunity to look at it yet, so I'm not exactly sure how they went about the cross-examination of it, but one of the things that I could see myself doing is, excuse me, sir, how many murders have you committed in your life? How many banks did you rob in your life? And how many times did you put your father in the trunk of a car and rob from him? Oh, none? Well, I'm glad that you were able to navigate that better than your brother. And I would have sat down and dropped the mic. I wouldn't have really gone deep into that. But do you think jurors are going to buy this? Or could they look at the brother's testimony and everything the prosecutor is saying is that this guy had choices. He just chose not to do right.
You know, gosh forbid I ever had to have a criminal attorney, Bob. You're the one I would hire because you get it. I think that's exactly what my point would be as prosecution, too, because like you pointed out, listen, a lot of people regrettably have traumatic childhoods, have mental health illnesses, have different things. Does that mean that it is a mitigating factor that the jury should say means he doesn't get death? Maybe, maybe not. Here's what I think it comes down to in my experience with juries: sympathy. How sympathetic are all 12, because it has to be unanimous, all 12 jurors to this gentleman and everything that's been introduced? And are they sympathetic enough in one case to say, you know what, all of these things in the kitchen sink that they're throwing out there, the childhood, the mental defects, all of that are enough to say mitigating factors when he should not get the death penalty? I don't know what they're going to do. I know,
Judge, you're like reading my mind. It's almost frightening out there from Atlanta to all the way here in New York, because I was going to say it comes down to a visceral response of these jurors in the end analysis, and they plug in the rest as they go along, but they're not going to execute somebody that they feel that they shouldn't. But that's where his testimony, I think, really, really hurt him, because they saw no remorse. They saw him actually joking about it. They saw no regret. He was flippant. He's argumentative. And then we have this whole back history of other issues. He just didn't come off as somebody where you say, gosh, I feel kind of bad for this guy, at least in my humble opinion. But you're right. It comes down to the visceral reactions of them emotionally. So, I mean, the defense has got a tough job on their hands here, folks, and they're doing what they're supposed to do, which is keep that defendant alive another month, another day, another hour, for as long as they can. Hope that maybe one juror at least or more, I don't think it's going to be an outright life sentence, but one of them says that they're not going to give a penalty sentence, and that's it for the penalty phase of that case. So the defense is fighting hard. Let's take a look at their opening statements. All right, well, there's the defense, Judge Ashley Willcott, trying to make the argument. And, you know, something that strikes me that I will say, and it's something that I would agree with as a juror. I wouldn't agree with it be a mitigating factor, but when she discusses there and when he discusses that I just basically get, I think he used a line, they spend $30,000 a year to keep me in and don't give you a nickel when you get out. And I'm just kind of going in my mind, I have a friend who was released, a lawyer, no longer a lawyer, was released from federal prison, and so many other people that get released from state and federal prison. And there is some truth to this aspect of what do they do afterwards? This guy's been out for 5 years. He can't get a job. He's got a conviction tag to him, and they become destitute. And it's no wonder that many people wind up repatriating themselves back into the system. I don't want to say that that's an excuse for him, but it certainly is something that generally applies. And if I were the prosecutor, I would consider bringing out statistics. Well, how many people in his condition that get out after 25 years commit murder? I'd imagine that number be pretty few. Maybe they commit crimes, but not murder.
It would be interesting to see what those statistics indicate, Bob, because I do agree. The reality is, often when they get out of jail, the things that you just cited, the things that he experienced, homelessness, destitute, unable to get a job, all of those things exist. But I'm going to counter that and say, on the other hand, we hear great success stories. We hear individuals who have been wrongly convicted and spent many, many years in jail who do get out and they're successful, absent the civil judgment. I'm not talking about that piece. So I do think that it's very possible, but statistically, they're likely, yes, to reoffend based on all the things you just described.
And you know, Judge, I can't get out of my head that no matter what you bring up in this case has a very special something to it. And most of the murder cases that I tried, certainly the death penalty cases, they involve people that had relationships with one another, and there was a reason you could put your arms around why it was it happened. You don't justify it, but you can understand it. Sex, money, greed, jealousy, those are usually the places they go. But this was a random person, and I bet every juror, there's something creepy, witchy, as Manson used to say, about this kind of thing, because it could be any one of them to no fault of their own. They're just in the wrong place at the wrong time. Judge Ashley, so I think we have an answer through Alina there that this witness did not do well for the defense in the case. And I'm just thinking that, you know, the jury's witnessing all of this, and this is occurring real time right in front of them. And you know how they are about judges. You are one. I mean, they don't like the jurors when the judge has to wrestle with people as well. That's just not a good look for the defendant.
It really isn't. Let me play devil's advocate, though, Bob. I just have to say, you know how this defendant's written 3 letters, one to judges? One of the sentences he wrote was getting the death penalty in blank, a word that I can't say, on media, hard because the prosecutor just don't know what may come to fruition before a jury. So devil's advocate, it might be that his outburst, the fact that nobody can control him, including his own attorneys, the fact that the judge, I heard say, Mr. Nelson, 6 different times to tell him to be quiet, a jury may feel like he's kind of pathetic. You can't control him. He's lost his mind. He's quote unquote crazy. And they may not want to send someone who's crazy like that to the death penalty.
I don't know. I'll play devil's advocate. Maybe this guy wants the death penalty, right?
Well, that could be.
Yeah, maybe this guy's going to get up there, and he clearly has indicated he wants to get up there at sentencing and saying, "I dare you to give me the death penalty. I don't care." He's just that out of control in my mind. But anyway, let's listen to what the judge's reaction was to all this. All right, so Judge Ashley, let me ask you, when is enough enough? He has a constitutional right to be there. He's had a couple of outbursts in front of the jurors. When does the judge, or you as a judge, get to a point where you'll deny him the right to be present during his trial because he's interrupting the proceedings?
All right. So first of all, let me say I think this judge is exceedingly patient. I like the way he manages his courtroom. I like the way he puts on the record very clearly everything that's happened. He's let the defendant get away with more than I would. The second time, if I had to continue to say Mr. Nelson and he wouldn't respond, I would have had him removed. I think this time when he gave his warning and said, you've done it twice before, do you understand my directions now? I think I would have gone one step further and not only said I could detain you, I think I would have said, and if it happens again, we're not doing this. You're going to be detained and you will not be in here for the remainder of your proceedings.
Give you maybe a little bit of a curveball, Judge, but the jurors have seen this. Do you give some sort of curative or limiting instruction to the jury, or if that's the way he acts, that's fair game? It's almost like credibility of a witness. A juror can assess that along with all the other evidence.
Well, I think that you have to tell the jury to disregard what he has said because he's not testifying. He's not under oath. So I do think I would say you cannot take into account anything that he said. The rest, I think I would allow them. They've seen it. You can't change what they've seen, but you have to tell them to disregard what they've heard, in my opinion.
Yeah, so do you agree with me that the prosecution was doing amen internally when that was going on in front of the jury?
Absolutely. Absolutely. And my prediction, Bob, I could be wrong. I just foresee that he's going to do it another time at some point during this.
Yeah, I think that we're in store for something else when he takes the stand in the penalty phase. This guy reminds me of something an old priest once said to me when I was a resident assistant, that he said, don't ever underestimate a narcissistic personality. They love attention, whether it's negative attention or positive attention. It does not make a difference. They like people talking about him. So I think he wants to put a wow factor out there, just like he did during the, gosh, I don't even know how I describe flippant, uncaring, narcissistic testimony that he gave in the guilt phase.
Well, definitely unsympathetic. You already pointed out, I think the last thing he garnered was any type of sympathy because he showed no remorse. In fact, as you well know, he decided to blame the federal probation officer and everybody else for his crime. It's not his fault. I do think the other piece of this is I would be a little concerned, like you pointed out, he does have a pen or a pencil there on the table. I just think that with this kind of personality, you have to be very cautious because if he loses his temper to an extreme, just like this was a random victim, who knows what he might lash out in court about. That's my little fear nagging at the back of my mind.
Yeah, I agree with you completely. I don't care whether it's a pen or a pencil. And I don't think he's got a great relationship with his lawyers, and he's under a lot of pressure, and he's got whatever illness or sociopathic tendencies that he's got, and there's danger for those lawyers. I wouldn't be sitting right next to him in the way that they are. I'm sorry to say that. And I'd also take protections that some courts have, that there's a device that they can put on him that actually shocks him down, like a shock vest or something. I think he's that dangerous, but maybe that state doesn't allow that there. Anyway, Judge Ashley Willcott, always awesome to have you on with your great analysis. As always, we're going to take a quick break, and we'll be back with more of the Scott Nelson trial on the other side.